Hello and welcome to the Rogers Brief for January 27th, 2024. I'm Adam Rogers. Thank you for watching and thank you for listening. Today I'm going to be talking about two stories mainly. One is the junior hockey players, the big story in Canada, the five members of the 2018 Canadian national junior hockey team going to be arrested this week in London. Turning themselves in to be arrested in London, Ontario, with allegations of sexual assault dating back a few years now. And so talk about that a little bit. And the other big thing I'm going to talk about is the Emergencies Act decision from our federal court this week. Justice Richard Mosley released his decision. And in that decision, of course, he ruled that the government was not justified, that it was unreasonable for them to invoke the Emergencies Act in dealing with the protesters around the trucker convoy. And I found that that was unreasonable to do. There was no national emergency, and also that there was a violation of some charter rights. So I'm going to do a little dive into that decision, talk about that, talk about the likelihood and of an appeal, the likelihood of success of an appeal, as well as some other things that may emerge from that decision. Before that, talk about a few other things that are going on. One is this week coming up, January 31st, the final report in the Desmond Inquiry is going to be issued. And certainly this has been a big part of my life over the last 5 years, so quite looking forward to the report being issued. I've been working with the Desmond family, representing them at the inquiry, and seeing them through some of the other issues as well associated with everything that's gone on. But the inquiry itself has gone through some difficult patches. One being the pandemic, which delayed the proceedings for a full year. So they changed locations, which wasn't necessary really, but it was done anyway to a larger courtroom in Port Hawkesbury, away from Guysborough. And then last summer, the provincial government, after issuing a couple of extensions, refused to further extend Judge Warren Zimmer to continue writing the report. He had reached the age of 75, which is the mandatory retirement age for judges, but they had extended him so he could finish the report, given everything, the delays because of the pandemic and all that stuff, and the importance of his continuity. But they reached a point where they didn't extend him further, and they appointed Judge Paul Scoville, judge out of Amherst, to finish the report, to write the report. So with all of that going on, it's difficult to know exactly what to expect from this report, but hopefully it'll be well done. I expect it to be an impactful report, certainly. So we'll look for that, and I'll be talking probably next week, and certainly when the report is issued on Wednesday. The other thing, just this past Thursday, I had an unique opportunity to go to the Mikmaq Friendship Center in Halifax. I was up for the Chamber of Commerce dinner that evening, but we went up early and was there with Rolf Baumann from the Friends United Foundation, donating some art pieces to the Friendship Center. Just an extraordinary place. They had thanks to Trina for showing us around, Elder Deb as well, and others. There's so much going on there. I think there's over 100 people working at the Friendship Center, and they're dealing with issues around housing. Many people trying to help out there. So this is for Indigenous individuals that are within the city mainly, but they do some services that are involved beyond the HRM as well. They have a space for, they have court support workers in there. They have counseling in there. There's a health center. They have education. There was a guy there working on a GED test. He was preparing to write a test later, I think the next day. And then they have a space there for, family visits. If you have court-ordered family visits, you can do the visits there under safe conditions. There's cultural education taking place, celebration, murdered and missing Indigenous women, those honored and remembered. There's red dresses hanging around. Anyway, just quite a place and quite a resource for Mi'kmaq people living in the city, and something that I think could really be expanded. Of course, they're building a new space in downtown Halifax, and I can tell you the services are needed and quite an operation they have going on there. All right, so talk about the story now. The other thing that's going on with me this weekend, I'm playing hockey. I'm playing down in Port Hawkesbury at the Tiger Mackey tournament. There's lots of teams playing. There's a women's division this year. I think 4 teams there. I find myself in the over 35 division, which we have 6 teams. 3 of them make the playoffs. I think we're pretty likely to. We've won our first 2 games. We've got to play a third one later today. And there's, I think, 8 teams in the open division. A lot of former Junior B players. Lots of a few names you'd recognize too. Alan McMaster, the finance minister, is playing nets for one of the over 35 teams. And, some members of the Cape Breton West Telus Cup national champions. Some of them are playing in the under division. So anyway, lots of good hockey, but a lot of talk about these junior players and the mess that they find themselves in. The biggest name, of course, is Carter Hart, goaltender for the Philadelphia Flyers, but also, a Team Canada goalie, a guy that would be one of the favorites. I certainly would have said this a couple of years ago, one of the favorites for making the men's team on Team Canada and being the starting goalie, and quite a legacy going back from Ken Dryden and Grant Fuhr and Patrick Waugh, Marty Brodeur, Luongo, all the way up through, and Carter Hart was sort of the heir apparent to that role. And now who knows what his career is going to look like. His performance, talking to a few people about this, Carter Hart's performance hasn't been up to his standards in the last couple of years, and I wonder if this has been hanging over his head some and affecting that, as you expect it might. But there's been a civil suit filed by the woman involved in this, and there's 5 players from that junior hockey team that are going to be charged, and there's some stuff from the civil suit that certainly suggests that there's strong evidence of something that went wrong, something that was, a sexual assault of some nature, potentially a very serious nature. And so there was text messages exchanged. This is what you look for in these kind of cases. You look for, real evidence, because of course, if it's just a she said, he said kind of a thing, then hard to know how it's going to turn out. But in this case, there was text messages between the players, basically inviting some of the other players into the room, and so there's some evidence of at least the gathering taking place, and then text messages from one of the players to the girl, to the woman, to asking her to drop things, to go to the police and tell them nothing happened, and just so. All right, again, those are things where it could be all right if nothing happened, but somebody was making a complaint. Yes, maybe you would ask them not to, but just the way the texts are written, there's no. It's more along the lines of you should go to the police and put a stop to this, not hey, what are you talking about? Nothing happened. You agreed to everything. Go to the police and stop it. Like that first section of, hey, this is all crazy. This doesn't make any sense. What are you doing here? That's anyway. Not that you can parse these text messages too much all the time, but that seemed to be telling. But the worst of it was these guys had the bright idea to have the poor girl make a video answering questions, as she was leaving, I think the next morning or that night, saying, hey, you consented to everything, didn't you? And, apparently she's crying in the video. She's very upset looking, and, obviously just done to, it's like a hostage video or something. So that doesn't look good at all. This is one of the stupidest things, well, other than the act itself, the stupidest thing they could have done. If, anyway, that's going to really come back on them. So we'll see what happens. But, I've been seeing these cases, sexual assault cases, particularly if there's rape involved. This is going to be bad. Like the Supreme Court of Canada a few years ago in a decision called Friesen, many people may be familiar with this, basically told judges across the country, whatever you're giving out for sentences on sexual assault cases, you need to ramp it up. Mid single-digit penitentiary sentences for sexual assaults of this nature, not unusual, right? So there's a real chance that these guys are going to go to jail, And so we'll see. We'll see what happens. If they'll be arrested next week. Maybe within a month or so, enter a plea, go to court to enter a plea, and then I don't expect they'll be held without bail. I suspect they'll all get bail, but enter a plea. If they do a not guilty plea, then months for trial. And I would expect, given the freeze and decision, and given just the social pressure on all of this, that the Crown prosecutor is going to be very, very reluctant to give out any kind of a plea bargain deal that does not involve jail sentences for these guys. At least if it's not quite clear, but it seems like maybe one of them was the main actor and others became involved. But if that's the case, maybe there's one more than others, but it seems like at least 5 of them are in pretty bad trouble. So we'll see. Certainly just mention that lots of people are talking about this. Nobody's defending these players. Nobody's talking about like, oh yeah, no, this is like a Trevor Bauer situation where somebody just out to get somebody that's going into professional sports. No, this nobody sees it that way from what I can tell. All right, so we'll see where that develops. They'll be arrested this week and take it from there. All right, so the other big story this week in law, aside from the story yesterday down in the States with Donald Trump and his $80-some million payment to E. Jean Carroll, I guess that's a big story in law too. But the big one up here is this Emergencies Act decision from Justice Richard Mosley from the federal court, well-respected judge. The litigation was led by the Canadian Civil Liberties Association and the Canadian Constitutional Foundation. There were a couple of individual litigants as well, but there was these two organizations, which, for litigation like this, it's expensive, there's a lot of research involved, a lot of time involved. Then it's very difficult for individual litigants to fund that themselves. So here's what happened. Went in through the litigation of the Canadian Civil Liberties Association and Canadian Constitutional Foundation, and good on them for doing so, putting their resources behind it. So reading some of the news and some of the commentary this week, much has been made of a couple of Justice Mosley's comments on hindsight. Right? Hindsight it's easy for me in a way, looking back on this, to say, parse the evidence and say that they hadn't met the threshold. If I was in their shoes at the time, he said in his judgment, wrote in his judgment that, I might have made the same decision, or, kind of understandable that they made the decision. And, many sort of latching onto those comments and saying, maybe it was, a light decision in a way. Don't quite read it that way. It says at first he thought he would approve, but then after submissions from the Civil Liberties Association and the Canadian Constitutional Foundation, he felt the other way. Well, that's a way the judge is supposed to act. You have an open mind. You may go in with a view, and then you develop that view as the submissions dictate. Well, anyway, I think it was just sort of like, yes. It's almost like if you're doing instant replay in sports, right? You might say, well, now that we look back on this, we can see it was offside, or it wasn't a catch in football or something like that. But because of the angle that the referee had, or somebody was in his way, you could see why he made the wrong decision. He or she made the wrong decision. Well, that's kind of what the Justice Mosley was saying. Well, they had to act quickly. This is the first time it's been invoked. One can see why they might have made that decision, but it was the wrong decision. It was unjustified. The other thing people are pointing to, which is legitimate, is that Justice Mosley has come to a different conclusion than the Justice Rulos, who led the inquiry that looked into the Emergencies Act, the invocation of the Emergencies Act. The biggest difference was, and I talked about this before on here, is Justice Rulos took a broader view of what it meant to be a national emergency. So in the Emergencies Act legislation, it talks about a national emergency being connected to the definition of a national emergency in the CSIS Act, Canadian Security Information Service Act, Intelligence Service Act. the spy agency and how they, in their legislation, define a national emergency, which, basically, there has to be a threat to the security of the whole country. Justice Rulos took a broader look at that. Justice Mosley did not, and in particular felt that economic impacts were not didn't count. Went through multiple precedent cases where it had been shown that economic impact did not count as well, threat or use of acts of serious violence. Well, that has to be violence to people, not to economic interests. The other thing that Justice Mosley talked about was that many facets of it, including in Coutts, Alberta, and other places, the border in Windsor, were dealt with by provincial resources, or were not beyond the capacity of provincial resources to deal with. The Emergencies Act is supposed to be a last resort, a tool of last resort. Well, all of the other tools were not tried. Now, he doesn't say you have to try and have every tool fail. I mean, if it's clear a tool isn't going to work and you need the Emergencies Act, well, sure. But in this case, regular laws, regular criminal laws, regular police resources, should have been able to handle this. It was his view. So those two things, I guess, the definition, using the Seizure Act as adopting that definition of a national emergency, and the security issues, that's going to be one area, I think, where the government will try to appeal this decision. And the other being whether economic impacts, you imagine at a certain level, the economic impact of something could lead to further impacts, which are certainly serious. It could lead to danger to people. But that wasn't certainly the case here. So because of that, because it was not beyond the capacity of the provinces to deal with, had they been more organized in Ottawa, and as was shown in other places, he said the invoking of the act was an unreasonable thing to do. So in the Seizure Act definition, it talks about a threat or use of acts of serious violence. So that's not just any old violence. It has to be beyond the norm, I guess, and that wasn't found to be the case here. And it was said it was relevant that the director of CSIS advised the Prime Minister and the Cabinet that it was not a threat to the security of Canada, in their opinion and under their legislation. So then the judge first said, okay, well, it was ultra vires, that is beyond the rights of the government to invoke the act. There was no national emergency, and so invoking the act was unreasonable. That was the first conclusion. The second set of conclusions was under the Charter. Was the legislation in violation of the invocation of the Emergencies Act in violation of the Charter? All right, so first, so he looks at Section 2, Section 7, and Section 8. Section 2 had three parts. First, the freedom of thought, belief, opinion, and expression. Okay, so was that violated? And he found yes, because not only were there violent and aggressive protesters, but there was just people there with them that were regular protesters, but the act applied to everybody. So it was, of violating the freedom of thought and belief, opinion, and expression of those non-violent, non-problematic protesters. So that was a problem. Was it a violation of peaceful assembly? No, he says, because you could have assembled anywhere. You could have assembled peacefully in those areas and not gone beyond that to blockade and protest in a violent way. You could have assembled and just not done anything violent, and it would have been okay. So there was no violation there. And freedom of association. So the freedom of association, he says, no, again, this was not violated, because the protesters were all free to communicate, associate with one another. So that act is distinct from whatever the protest is, or whatever the action is taken. All right, you associate, you discuss what you're going to do, you discuss your issues, your ideologies, or whatever you want to discuss as you associate. But then what do you do as an association? So it's the first part is the freedom of association. That was not violated. Everybody was free to communicate there. So a violation of Section 2, but only under the freedom of thought, belief, opinion, and expression. Second part was Section 7, which is the right to life, liberty, and security of the person. It says no, because the measures here were only temporary, and they were subject to judicial review, and so he says that was not contrary to the principles of fundamental justice to have temporary measures in place to deal with a temporary emergency. Next is Section 8, which is the right to be free from unreasonable search and seizure. And in this case, the judge said yes, there was a violation because under the Emergencies Act, everybody's financial information could be taken and used and bank accounts frozen. So the data that the banks were obligated to disclose, that is being seized in a sense, that data, that information. So the government would know about your finances, maybe your habits as a result of getting into your bank account, and they were seizing it in the sense that they were freezing it and you couldn't use it yourself. And there was the second problem with that was that there was no objective standard behind that. So sometimes it was the people involved in the protest, sometimes it was their family members or parties that weren't directly involved. So he found that was a problem, and it was a unreasonable search and seizure. So whenever there's a charter violation found, then the next step is to take it to the Section 1 justification. Is it justifiable in a free and democratic society? First, okay, there's 3 steps to this. There's always 3 steps in a legal test, it seems. There's a pressing and substantial objective. 1, is it proportionate to the objective? Like, is it related to, does the response meet the problem? And then thirdly, was there a minimal infringement of the charter rights? And usually it comes down to the third part of that test of whether there was a minimal infringement. In this case, the judge says, well, political speech is granted a very high level of protection in terms of charter rights. And here it was overbroad in one way to apply the act all across Canada rather than just in the areas where it was needed, in their view, in Ottawa, in the government's view. Other areas had already been cleared up, and premiers of most provinces had said that it wasn't necessary to invoke the act in their provinces. So it was overbroad in that sense. And then it was overbroad as well because it included bystanders as well as the more assertive or aggressive protesters. So it was not saved then. It wasn't justified. The violations of the charter were not justified under Section 1, and so the act was deemed to be a violation of the charter. So what does this all mean? Well, it is, in the one sense, guidance for future governments. If there's an emergency, if it's the same with any new law, right? If it hasn't been tested, it's difficult to know when to apply it. Now it's been tested. It's been analyzed very thoroughly in this decision by Justice Mosley. And so now future governments, if they don't amend the act, and I'll come to that in a second, if they don't amend the act, then they'll know at least more clearly how and when to apply it. The second thing is, of course, this is likely to be appealed. The government has already said that. So we may get some further guidance from appeal court justices on this. But I don't know. I mean, the part about the national emergency, I thought that I kind of predicted that Justice Rulos was going to take a broader interpretation of that in the inquiry. So there's still, I think, some daylight there where an appeal could at least be argued. Do think, that Justice Mosley's reasoning was pretty strong here. I think that'll hold up, but at least there's something there for the government to say. I mean, 2 things an appeal does. 1, it could change the outcome. Secondly, it just delays the decision. You can always say, well, it's under appeal. It's not. We didn't really lose in a sense yet because we're still playing. So they can take that out for a few months while they think about what else they're going to say. The other thing is the judge kind of suggested, especially with the economic impact side of it, that there might be some room for legislative amendments, and that may be something they do. If the judge is saying economic impacts don't matter, well, put it in the legislation and it will matter. So that may be the subject of an amendment if the government can get other parties to agree that that is appropriate to do. So we'll see how that develops over the next while as well. All right, so those, by the way, so The last part of this, the other news this week was that the Justice Minister at the time when the act was invoked, David Lametti, who was then demoted from the Justice portfolio from Cabinet, he left Cabinet, or was demoted from Cabinet, has now quit politics and has gone to join a big law firm in Toronto. So, and apparently this law firm is representing the is working against the National Post, who's has some legislation going on about the emergencies, not the Emergencies Act, but the pandemic response. So, anyway, some controversy there. But David Lametti's, who was a professor at McGill, a law professor there, had come in with, a lot of, a lot of expectations for him when he was named Justice Minister after Jody Wilson-Raybould was kicked out of the role. But certainly hasn't distinguished himself. We have this Emergencies Act declaration that was declared unconstitutional. That's not a great sign. And anyway, so he leaves politics certainly without a stellar record. All right, that's what I wanted to cover this week in the Rogers Brief. Thanks everybody for watching and listening. We'll be on tomorrow night with Jordan and Paul for the Sunday night show as well. So you can catch that as well if you're interested. You can have the football game on one screen and the Sunday night show on another, starting at 9:15. So look forward to that. Otherwise, thanks again for watching and thank you for listening, and we'll see you next time.